The Skandia case, case C7 of 13, is an interesting new decision on groups of companies which could have some far-reaching effects. It only came out at the end of September, and businesses and advisors are still digesting its implications. The starting point is that Article 11 of the Principal VAT Directive allows member states to regard separate persons as a single taxable person. There's nothing much in the directive about when this applies or how. The article refers to the inclusion of persons who, while legally independent, are closely bound to one another by financial, economic and organisational links. A member state exercising the option provided for in the first paragraph may adopt any measures needed to prevent tax evasion or avoidance through the use of this provision. Apart from that, it doesn't impose any requirements. Some member states have adopted it and some haven't, and those that have done so in different ways. One aspect of the rule was examined by the Court of Justice recently in a case brought by the Commission. The Commission decided that a holding company should only be allowed to join a single group registration with other companies in its group if it was a taxable person in its own right. The Court of Justice disagreed with the Commission. Their view was implied by the wording of earlier directives, which referred to the inclusion of taxable persons in the single registration, but the Principal VAT Directive has dropped the word taxable and just refers to persons. So the main remaining condition is that all the businesses must be established in the territory and must be closely linked economically, organisationally and financially. The most common, although not the only application of the rule, is allowing groups of companies to join together and make a single VAT return. Bear in mind that this is not allowed across country boundaries. All the members of the group must be established in the member state, either with their main establishment or another fixed establishment. That's the point of this case. It's also important to revisit the case of FCE Bank, which affirmed an important distinction between an international business operating through branches and another one operating through subsidiary companies. If you have a holding company with a subsidiary in another country, they are independent legal entities. That means that something supplied by the holding company to the subsidiary is capable of being a supply for consideration. So intra-group transactions in services will generally be subject to a reverse charge, where the subsidiary pays for something supplied by the holding company, such as management services. FCE Bank had a head office and a branch structure. They looked like independent businesses because each was separately registered for VAT in its respective country, the UK and Italy. And as a result, when the head office had recharged some costs to the branch, it had treated it as if it was a supply of services and had accounted for a reverse charge in the branch. Then they realised that they shouldn't have done so, and they asked for the output tax on the reverse charge back from the Italian authorities. The Court of Justice confirmed that there can't be a supply between a head office and a branch. They're part of the same entity and are not independent of each other. Only independent economic operators can make supplies to each other. There are limitations on that, of course. There are deemed supplies in various areas of the directive that don't involve another economic operator, but none of them applied here. The Skandia case has demonstrated that there is a limit to the principle of FCE Bank. The structure of the Skandia Group is as follows. Skandia is an American company with a branch in Sweden and also subsidiary companies in that country. Under Swedish law, the branch was eligible to group with the subsidiaries because the branch was an establishment of the American company within Sweden. The US company had the responsibility for making central purchases of IT services for the worldwide operation. The company purchased these services in the US and supplied them to its branch for payment. The branch supplied them on to members of the Swedish VAT group, also for payment. At each stage, a 5% markup was applied to the transfer price, so it looked like a supply for consideration. The supplier was making money out of the transaction. Bear in mind that there may well be direct tax rules which affect this sort of transaction, transfer pricing rules that are insisted on by the tax authorities in different countries to stop profits being leached out of their jurisdiction. For VAT, the main thing is that there is consideration, not how much it is. The company saw the transactions as not creating a VAT charge. The purchase of the software happened in the USA, so that wouldn't be vatable. The transaction between the head office and the branch was covered by the decision in FCE Bank, so that wasn't vatable. And the transaction between the branch and its fellow group companies was ignored for VAT because it was happening within a single taxable person. A bit like FCE Bank, but under the specific rules of group registration in Sweden. So no VAT there either, no VAT anywhere. The authorities, on the other hand, reckoned that there was a purchase of software outside the EU that was being used within the EU, and the right answer had to be a reverse charge in Sweden. They decided that the transactions between the US company and the branch were taxable, and the company was liable for a reverse charge. The Swedish court referred questions to find out if this was correct, and if it was, who was liable to pay the tax. The court had to consider whether there was any reason to depart from the FCE Bank decision. It saw no reason to change the principles of that decision. It remained correct. The court observed, though, that the FCE Bank decision depended on the branch not carrying on an independent economic activity. If it bore the economic risk arising from its business, it would be independent. But in this case, the branch was not independent of the American company. However, it was also a member of a VAT group. That meant that it could no longer be regarded as part of the company that it belonged to. A VAT group is a fiction created under the provisions of the VAT Directive, and once you've entered into that legal fiction, the facts no longer necessarily determine the outcome. You have to follow through to the logical consequences of your game of let's pretend. Once a VAT group has been registered, it is treated as a single taxable person, and the members lose whatever separate identities they might have had before. So the branch was no longer a branch of its head office, but was more closely attached for VAT to the single taxable person in Sweden. That meant that the supply of services by the company to the single taxable person, provided for consideration, had to be regarded as a taxable transaction, and a reverse charge applied. The head office might be regarded as having a fixed establishment in Sweden that would make it registrable there, but that fixed establishment was the branch, and it was part of the VAT group, and it was therefore not to be regarded as part of the head office anymore. So the reverse charge fell on the VAT group. The decision only came out late in September, and immediately commentators noted that it could have a serious effect on international financial companies, particularly those based in the USA. A supply of staff from a head office to a branch has traditionally been ignored because of FCE Bank, even if the salaries of the seconded staff are recharged back to the head office. This decision suggests that there could be a sticking VAT cost in that situation if the branch is a member of a group within the EU country. The recharge would become a taxable transaction. The EU grouping would be liable to a reverse charge on the cost of the salaries, and if it was a largely exempt business, it wouldn't be able to recover that VAT. We'll have to wait and see what comes of this.